Hi everyone, this is Basanta along with a group of 4 members. Actually, we chose to work on the case of Jublie Mine NL versus Reily 2009. This presentation comprised of 3 sections: introduction, second one is discussion and analysis of the court and tribunal decision. And now my friend is going to start with the introduction.
Hi,
Thank you.
my name is Sunil Khanal and I'm a student of Business and Corporate Law. Today I would like to give you some information about a case that took place in the year 2009. The parties involved in this case were an Australian based mining company known as Jublie Mines and one of the shareholders, Reily. In the year 1992 and 1993, Jublie Mines was involved in gold exploration. Later, on June 11, 1996, Jublie Mines announced the presence of nickel and presented a report. This report was handed over to Jublie Mines in the year 1994 by Western Mining Company. This report was not announced to public because the managing director, Mr. Crossley, and geologist Mr. Cook has a point. The point was their primary intention was not nickel exploration. Because of this announcement, the price of the shares increased by 9%. Then Mr. Reily, who was among one of the shareholders, filed a petition against Jublie Mines for not announcing this report to the shareholders. And because this report was not announced to shareholders, they had to bear some losses because they didn't knew the actual price of the shares and they sold their shares in very much less price. Their appeal was accepted by the court and they were handed over $1.8 million as a damage claims. Later, in the year 2006, the case was reassessed because the Jublie Mines company argued that their intention was not nickel exploration, hence they don't have any obligation to share this report with shareholders. So the court heard both of the cases and settled the case accordingly. But the duties and the violations and the duties and violations were done. By not sharing this information, the company Jublie Mines NL and its directors have breached the duties responsibilities as advised by the Australian Securities Exchange framework. The rules that the company breached were violations committed on account of continuous disclosure regime and the allegations of negligence on account of failure in releasing the information, and also they breached and violated the Australian Securities Exchange listing rules.
Thank you, team, for giving me a chance for continuing the presentation. Hi, it is MD Sharpatosan. Now I am going to describe impact of the decision on the operating of companies in Australia. The impact of the decision are long-lasting and very beneficial for the companies operating in Australian territories under the Australian Corporation Law. Since the decision has benefit some prerequisites for the companies and the information rights of the investors and other stakeholders. Benefits for this decision: enhance the investment efficiency, accounts resulting greater investor confidence, greater financial activities in the investment market. The case has set ground up for some continuous disclosures from the companies about their business operation, enhancing their efficiency in allocating their resource, reduce dispersion of price, offering an informed choice from a rank of available investment opportunities for the potential investors, timely and correct disclosure of business information. Under the continuous disclosure framework, the company and their directors are bound to disclose all investment company related information in the with transparency, honesty, with a restricted unethical business practice, including corporation fraud, misrepresentation, or manipulation. The continuous disclosure restricted and disclosure false reporting and ramus in the corporation business world, according Australian Corporation Act 2001 and Companies and Consumer Act 2010. Continuous disclosure serves as a very effective accountability tool and mechanism against the companies and their directors, because they may not provide complete information to the investors, or only the information was asked by investors, while there may have other information potential informative and essential for the decision making. Under the continuous disclosure, this act is also accountable. The company or their directors can be taken to court for not providing complete information. At the same time, the company or its directors are accountable and answerable to court in the events of misconduct or use of company's information of their personal benefit. Thanks, that's all about me. Now I would like to invite our next group member to continue the presentation.
Hello, hi. My name is Asfanmani, and I'm gonna talk about the decision which they made by tribunal on this regarding this case. So as it goes, it set a framework actually for the other governing bodies, big firms and big managers to have a smooth and ongoing and really transparent corporations. So yeah, so in this the decision had questioned the Australian Security Exchange and Security Investment Commission. And also the sharing information under the continuous disclosure regime about the role of listed companies and their directors. The effectiveness of this continuous disclosure rule extend to the monitoring and enforcement under prevailing regulatory structure. The decision has set ground for right and obligation for all stakeholders. So yeah, as for the it goes with the impact of this decision, it has a great impact on the corporate organization and individual investors decision making process. The decision has helped the investors by assessing the right kind of information and at right time, enhanced investment and efficiency and accuracy, resulting in greater investor confidence and greater financial activities indeed. So it also will boost activities and honesty, fair market practice while restricting unethical business practices. So the last one, not the least, facilitate accountability and audit of individual from large organizations and financial sectors. That's done for our presentation. Thanks so much.